So without further ado, I'm pleased to introduce Drexel Law Professor Lauren Katz-Smith, who will be moderating our third panel of the day titled Parenting and Families.
Thank you, Emily, and thank you so much to the Law Review for inviting me to moderate this distinguished panel on parenting and families. COVID-19 has definitely impacted parents and our families in a variety of ways. And to borrow an analogy from Indra Lucero, who spoke about the human right to connection and support in the context of childbirth and neonatal care, COVID has definitely created a portal into the ways that our systems and structures are failing families and failing to support families. So this panel will critically examine the ways that families have been uniquely affected by COVID, and our speakers will engage us in discussion about the opportunities for connection and for reform that present in its wake. I'm going to introduce all of our incredible panelists in the order that they will be speaking today and then turn things over to them. We'll be sure to save some time at the end for questions and discussions. Rebecca Feinberg is a professor at DePaul University, where she's cross-appointed between the law school and the College of Science and Health. Her research focuses on the law and ethics of reproduction, with a specific focus on assisted reproductive technologies. Professor Feinberg will describe the issues that were raised when many fertility centers chose to close or go to minimal services for the first few months of the pandemic, and how COVID-19 has affected our understanding of what constitutes essential medical care. Sarah Katz is a law professor at Temple Law, where she directs and teaches the Family Law Litigation Clinic. Her students handle custody, child and support, and spousal support, adoption, and other family law matters in the Philadelphia Family Court. She researches and writes about trauma-informed legal practice and the child welfare system, child custody, intimate partner violence, and other family law topics. Today, Professor Katz will speak to us about the pandemic's effects on access to family courts, access to domestic violence resources, and involvement with the child welfare system. Next, I'm so pleased to introduce Anna Ahrens, an acting assistant professor of lawyering at NYU Law. Her research focuses on the government's regulation and policing of families and the intersection of parental rights and race, gender, and poverty. Today, her remarks will focus on the harrowing narrative or the rhetoric regarding the safety risks that COVID-19 posed for children, and at the intersection, the reality that despite the lack of state oversight and intervention, the number of reports and investigation of child abuse and neglect fell by half, begging us the question about the role of the large regulatory state in the lives of families. And finally, Courtney Jocelyn is a Martin Luther King Jr. professor of law at the University of California, Davis School of Law. Professor Jocelyn teaches in the areas of constitutional law, employment discrimination, family law and sexual orientation, gender identity, and the law. She is a leading expert in the areas of family and relationship recognition, with a particular focus on same-sex and unmarried couples. Professor Jocelyn serves as the reporter for the Uniform Parentage Act 2017. And Professor Jocelyn today will describe the limitations in existing state parentage law, including the law of Pennsylvania, and talk about how one model act, the Uniform Parentage Act, addresses many of the critical gaps. So a warm welcome to all of you, and thank you so much for being here to share your incredible work with us. Professor Feinberg, I'm going to turn it over to you and mute myself.
Excellent. Give me 1 second to share screen with you. So to start, thank you very much for inviting me to speak today. I'm very excited about the topic of whether or not we qualify fertility care as an essential service within the healthcare industry. So to start, we have a very brief period of time, so I want to move right into the meat of the presentation. So to start, I want to talk about what the ASRM, the American Society of Reproductive Medicine, recommended during this time. So we're going to start by focusing on their very first set of guidelines that came out on March 17th, because they track through all the other guidelines throughout the time. So you should know in advance that the American Society of Reproductive Medicine, the ASRM, gave these guidelines that within a week, almost identical guidelines came out from ESHRE, the European Society for Human Reproduction and Embryology, and from the British British Fertility Society. And then of course, Spain and a number of other countries that have large fertility industries also gave very similar guidelines throughout the time. So this March 17th is the initial practice suspension recommendation, and the ASRM focused on 5 recommendations. The first was to suspend the initiation of new treatment cycles. The second was to strongly consider canceling all embryo transfers. The third was to consider care for patients who are in cycles, so to finish their cycles but not start additional cycles, unless people fell into a specific category called urgent requirement, which are patients who are receiving treatment for what we call gametotoxic therapy, therapy that would damage their gametes, their sperm and embryos, for future use. So these are oncology or cancer patients who are going to receive chemotherapy or radiation, or there are certain rheumatologic diseases that fall into the same category. The fourth recommendation was to suspend elective surgery, and all non-urgent diagnostic procedures. And the fifth was to minimize all in-person interactions by increasing telehealth. So this is the big recommendation that came out for all fertility clinics from the ASRM on March 17th at the very beginning of the pandemic. And then they also made the commitment that at least during the peak of the pandemic, the ASRM committee would meet and set out a new set of guidelines every 2 weeks. So I'm going to do a Speedy Gonzalez version through the last 20 months of these 2-week recommendations. March 30th, nothing changed, just repeated those 5 recommendations. By April 13th, they were getting a bit of kickback for recommending some shutdowns, and it was the first time that they openly mentioned that fertility services are essential, and they used the terms that US states and localities were appropriately, they used the term appropriately, recognizing infertility care as an essential service. By the end of the month, they state that infertility is a serious disease that requires treatment in a timely manner. And they go on to start talking about how they want to gradually and judiciously resume the delivery of reproductive care. In the middle of May, they start to talk about testing for COVID-19 and infection during pregnancy. And they cite a couple of very small studies that demonstrated that women who were COVID-19 positive, their fetuses, the amniotic fluid, the cord blood, and the breast milk did not show any evidence of viral DNA. So we are not seeing teratogenicity. We're not seeing anything cross the placental barrier there. In June, they start to talk about partner participation, because up to this point, clinics were only allowing the patient in and not the partner. And they start to talk about PPE requirements. In each of these, they are still reiterating those initial 5 recommendations. Then you see a period of time as the pandemic kind of flattened from August 10th, September 8th, October 6th, November 17th, where we started to just see the same discussion over and over again about how to safely and carefully reopen fertility practice. When we see our next big change is on December 16th with the first mention of vaccines. This is shortly after the emergency use approval comes out from Pfizer and the day before the EUA comes out from Moderna. And they specifically talk about the risks of COVID-19 that are now identifiable for pregnant women, and then therefore need to vaccinate all pregnant and lactating women. By January, they're talking about all 3 vaccines, the 2 mRNA vaccines that I've already mentioned, plus the adenovirus vector vaccine, which is the Johnson & Johnson that had just received an EUA, or just applied for their EUA. And they cite some very large end-value studies from the CDC, the roughly 44,000 participants in size, that demonstrate that the mRNA vaccine is safe during pregnancy and that it does convey some passive immunity to the baby. And then we see a huge gap of time right up to May of this year when they start talking about staff recommendations to mandate all staff in fertility clinics, not just patient-facing staff, but all staff to be vaccinated. They very quickly jump on board with the terminology of pandemic of the unvaccinated because they have evidence that women are much more susceptible to COVID-19 and to complications from COVID-19, as are their fetuses during pregnancy. And then they also talk about the low rate of vaccination compliance among pregnant women, in large part due to age. Young women in general were less likely to be vaccinated at that stage. And then the most recent is from August, and that's when they start to talk about the Delta variant. Just for those of you who are particularly interested in disparities, I do want to point out that even though the ASRM put a pause on, or recommended a pause on fertility treatment, particularly focused on not doing embryo transfers and getting women pregnant, there was no similar statement from ACOG, the American College of Obstetrics and Gynecology, saying that women who would procreate naturally through sexual activity should wait to get pregnant. So this is a disparity we see between assisted reproduction and natural reproduction. So now that we know what the ASRM has recommended and the guidelines that they've given, let's talk about the three options of what actually happened. There were three big choices. A lot of clinics stayed open. Yes, we're open. There was heavy criticism that these decisions were financial and business related rather than healthcare or health oriented in their decision making. There were quite a few that closed completely, particularly smaller clinics, and they claimed that they did so to protect their medical staff from infection. But people didn't actually acknowledge that this was protection in the short term from infection. In the long term, there's some question about, was there any protection from job loss and how that affects the staff of these fertility clinics. But the vast majority went with what's called limited opening. And limited opening is exactly what the ASRM was recommending, meaning to focus on fertility preservation and not to focus on implantation or getting women pregnant. So they were looking at harvesting eggs and sperm and cryopreserving them. And colloquially in the industry, they referred to these three choices as fight, flight, or freeze. Fight to stay open, flight to out of your closed clinic, or freeze with limited treatment for cryopreservation. And there are really two big populations of people who are analyzing this. So let's look from those two perspectives. And the first is the perspective of the practitioner. So the practitioners clearly had safety and infection concerns. They were looking specifically for PPE for to be safe for their staff and for the patients to come in. Remember that fertility clinics have to have a fairly deep bench. It's not just a doctor and a nurse, it's doctors and multiple nurses, as well as patient-facing administrative staff, anesthesiologists, embryologists, andrologists. And don't forget that this is the very early stages where we didn't have any idea how COVID was transmitted. So there was some question about whether it was just aerosolized or whether there was fomite transmission, and we didn't have PPE for enough PPE for staffs. Masks were very difficult to come by, especially N95s or KN94s or KFs. But in addition, cleaning to sterilize between patients before we knew that there was no fomite transmission was a great concern. But also in the limited resource section, you have to look at the healthcare industry as a whole. Healthcare as a whole was being incredibly taxed, and there were limited access to hospitals where beds and practitioners and staff were very limited in number or availability. And so anytime that you're going to do something like stimulate a woman's ovaries and do a surgical procedure to harvest eggs, you incur a certain amount of risk of complications such as ovarian torsion. And so fertility clinics have to take into account concern that if there is a complication that requires higher acuity, that there needs to be hospital beds, surgeons, and anesthesiologists, and staff to care for the patients who've experienced a complication during their fertility treatment. And then the last is a very common sentiment expressed by practitioners, because again, reminder that we're at the very beginning stages of this pandemic. We didn't know how COVID would affect either the pregnant woman or the fetus, and ultimately long-term the resulting child. So a lot of practitioners expressed great concern about being involved in creating a pregnancy where it could lead to detriment, and we now know can. A woman who catches COVID-19 during pregnancy has much greater likelihood of preeclampsia, much greater likelihood of hospitalization, intubation, and death, roughly 70% greater according to the CDC. And we also know that much greater likelihood of prematurity, which is negative, has negative ramifications for the fetus. Also, in the idea that this is very early in the pregnancy, we didn't know if embryos or gametes could either contract or pass the virus. And you're storing multiple sets of these in communal cryopreservation tanks. So there were lots of questions to be asked that practitioners were concerned about, rightfully so. The other perspective to look at is the patient perspective. And the biggest issue for most patients was mental health challenges during this time. It was incredibly stressful. Fertility treatment comes with a tremendous amount of ambiguity to begin with, but this lack of knowing or understanding when things might open, when they might be able to resume care is very significant, particularly for women of advanced maternal age, those with diminished ovarian reserve, and time limitations who are kind of sitting on the precipice of the fertility cliff or already sliding down the fertility cliff and just watching it get steeper the longer the pandemic drags out and the fertility clinics stayed closed to them. And there are a couple of really great studies that watched social media accounts and found that infertility patients were increasingly relying on sources like Instagram, both to manage their expectations and to understand the closures, because most fertility clinics did a very poor job of communication during this time. And there are great quotes in these studies from women who say things like, "I'm normally pretty resilient, but this has really floored me." And there's also, just so you know, a couple of really strong studies that demonstrate that men who are having infertility quandaries were equally emotionally affected as the women, and that their fertility cliff was also affected. And again, just to, the tangents are always half the fun in any presentation, but that last note that I have at the bottom of this slide is particularly interesting, that as and when clinics reopened, we actually saw a reverberation to this, in that we've seen a tremendous increase in oocyte cryopreservation. Lots of hypotheses why. We can talk about that during the Q&A if there's time, but I just think it's an interesting offshoot of this whole discussion. So now the meat of the discussion. What is essential care, and is fertility care essential? So we compare fertility care to other forms of corporeal medicine, and very commonly compared to oncology, where you talk about something being life-saving versus life-altering. Clearly, an oncology treatment is life-saving, fertility treatment is life-altering. And at the other extreme, you can talk about certain dermatologic or plastics, where they're definitively life-altering, not life-saving. And where does fertility fall out on the scale in between those? And is it comparable to any of those other forms of corporeal care? One of the biggest things that separates fertility care from all the others is funding. So we know that the vast majority of fertility care is self-funded and not insurance funded. And we know that 15 states in the union have some requirement for insurance coverage, but only 4 of those require any treatment. 11 of them require just diagnostics. So that really, the money element sets this aside, because lots of women had thousands and thousands of dollars of personally purchased pharmaceuticals that were sitting in their refrigerator going to expiration date. They were just traumatic for most women. The other thing that really sets fertility care apart from other areas of corporeal medicine is the level of interaction with business practices. So all areas of medicine interact with pharmaceutical companies and biotechnology and other things along those lines, but fertility care interacts even further with not just biotech and pharma, but with egg banks and sperm banks and surrogacy agencies and matching agencies and fertility attorneys and all kinds of other for-profit portions of the industry that do have that humanitarian obligation, but are not just pure, they do have a purely business or fiduciary obligation. So With note to the fact that I'm already a minute over time, I will say I'm looking forward to having a discussion about anything you want to raise during the discussion answer session, but I have thrown my email and phone number up here because I'm happy to continue this conversation offline with anyone who wants to further discuss it. And again, I thank you for allowing me to raise what I consider very substantial issues and look forward to the conversation at the end.
Thank you so much, Professor Feinberg. I'll turn it over to you, Professor Katz.
Great, thank you. I am delighted to be here for this important and thoughtful symposium, and I'm particularly delighted that the organizers included this panel and discussion about parenting and families as part of a larger discussion about the pandemic's impact on reproductive justice. Stability and integrity of families is a critical part of reproductive justice. And it's particularly an honor to share this panel with scholars like Courtney and Anna and Rebecca, whose work I admire. In thinking about what I wanted to share with you today, I thought what might be most interesting is some perspective on how families involved in family court disputes or needing access to family court have weathered the pandemic. As a clinical professor at Temple, my students and I represent approximately 130 parents and caregivers per year in an array of family law disputes, including custody, child and spousal support, adoption, protection from abuse, and other issues. I'm hoping that our practice experience provides some examples and context for the serious challenges to the integrity and stability of families that the pandemic has caused. I'll focus on access to the courts, particularly in custody cases, as well as concerns related to intimate partner violence and the child welfare system. When the world shut down in mid-March 2020, my students and I were in the midst of a busy semester, weren't we all, with many family court hearings scheduled the remainder of March and April 2020, as well as dates scheduled beyond that. Every single one of those hearings was canceled, with families who had already spent many months waiting to resolve their disputes now hanging in the balance, unclear when, if ever, they might be able to come before the court. Philadelphia's family court remained closed and not hearing cases from March 17th, 2020 through June of 2020. Due to pressure from amazing local advocates at Philadelphia Legal Assistance and Women Against Abuse Legal Center and others, the family court eventually found a way to be open for protection from abuse filings. The process for doing so during the pandemic was not well publicized, and many survivors continued to assume that help was not available and that the court was inaccessible. By the time the court reopened for virtual video hearings starting in July of 2020, there was an extraordinary backlog of cases. The court canceled all existing court dates for the remainder of the year of 2020 and set about the difficult task of relisting each of these matters virtually. Although the court reopened for in-person hearings in July of 2021, there remains a tremendous backlog of matters, which makes it challenging to get into court to resolve disputes in a timely manner. This lack of access to the courts had a devastating impact for many families. In custody cases, I found it took two potential paths. For some co-parenting families, the pandemic and lockdown and the need for health precautions forced them to set aside whatever were their differences and sort things out. These families revised their own custody schedules, worked out necessary arrangements to ensure children had access to both parents, and also ensure that the children could safely and meaningfully participate in remote learning. Arguably, the object lesson here is that for some families, access to mediation or other alternative dispute resolution mechanisms can be an effective tool to resolve custody disputes and relieve overburdened family courts' docket. The reality is that even prior to the pandemic, studies have told us that the vast majority of separating parents are able to work out their co-parenting plans without requiring court intervention. As a side note, these statistics always feel very surprising to me, given the sheer volume of custody disputes our courts see each year. In Philadelphia, there's an average of 10,000 new custody petitions filed each year. And statewide for Pennsylvania, it's 47,000 new custody petitions filed each year. Despite that apparently only represents about 20% of separating families. But these same studies tell us another important fact about separating families who can't work out their custody disputes and for whom family court intervention is necessary. Among these families, those 20% who can't work it out, intimate partner violence and/or family violence is remarkably prevalent, a major factor in somewhere between 50 to 75% of the cases. For these families, quote unquote, working it out is unlikely to be a meaningful option, and the courts, the family court, plays an important role in resolving these matters. Which brings me to the other path custody cases took. In many situations when the pandemic hit, parents took advantage of the circumstances to withhold children from the other parent or make other unilateral decisions for the child. With limited access to the courts, this bad or arguably abusive co-parenting behavior went largely unchecked. I can think of many egregious situations from my clinic's caseload or that of other attorneys I know, but I'll give one example. For one parent we represent, whose child was just 1 year old when lockdown happened, the other parent withheld the child for the remainder of 2020. During that time, our client feared for the safety of their child because of the other parent's past history of intimate partner violence and child abuse and a history of substance abuse by the other parent. Meanwhile, the other parent relocated to another county with the child and then began sending the child to daycare, causing another set of COVID concerns. Despite representation by our office and exhausting all means to enforce custody, our client ended up missing nearly an entire year of their child's life, despite having been the primary caregiver up until that point. Sadly, that client situation is not unique, and our custody court is still addressing the impact of abusive parents' decisions during the pandemic. For that particular client, we filed various motions and petitions to ensure our client eventually got the full and fair hearing they deserved. And while the client regained custody of their child, they can't make up for that lost year. And for clients who didn't or don't have an access to an attorney, which is estimated to be 85 to 90% of litigants in Philadelphia Family Court, wait was even longer. This underscores the importance of meaningful access to family courts, but also the critical importance of attorneys in ensuring the stability and integrity of families. The pandemic also had a significant and frightening impact for survivors of intimate partner violence and their ability to get the help and support they need. As lockdowns went into effect across the country, advocates sounded the alarm that survivors of intimate partner violence would be locked down with their abusers and unable to access help they needed. And while we don't have great data about whether there was a rampant increase in intimate partner violence during lockdown, we do know that there was a dramatic decrease in calls for help. For example, from January to May of 2020, calls in Philadelphia to 911 to report intimate partner violence and/or sexual assault decreased dramatically. There was a similar dramatic decrease to the citywide domestic violence hotline. There was also a significant increase in hang-ups mid-call to the citywide domestic violence hotline, which raises concerns about whether the survivor became unsafe in the midst of the call. However, in 2021, the Philadelphia domestic violence hotline slowly returned to a normal rate of calls received and ultimately received an increase of calls by 14%. But interestingly, the number of calls by survivors themselves dropped in that time by 11%, indicating an increase of third-party professionals calling for resources. Anecdotally, we know that the decrease in calls and the hang-ups meant that many survivors went without access to needed safety resources, such as counseling, housing, and other help. Similarly, calls to both of the Philadelphia Legal Services agencies that primarily serve survivors of intimate partner violence decreased dramatically. One agency indicated calls to their intake line decreased by 35% during lockdown. Calls to my own clinic's intake line dwindled. Survivors may have assumed that legal help was not available during the pandemic, or they were unable to safely call for help. And we know, again, anecdotally, that this lack of access to legal help and therefore the courts potentially compounded the dangers for survivors. Finally, the other area where the lack of access to the courts significantly compounded the situation for families during the pandemic was for families entangled with the state family regulation system, otherwise known as the child welfare system. As Anna details in her incredible article, which she'll undoubtedly discuss in a few minutes, many hysterically sounded the alarm that the shutdown of in-person schools, childcares, and other places where children interface with mandatory reporters would result in a rampant increase of unchecked and unreported child abuse. But as Anna debunks, there truly is not data to support that this occurred. Less government intervention with families is good for family integrity and stability, particularly given that the primary intervention low-income Black and Brown families are offered by the child welfare system is family separation. For families whose children were already in foster care, lockdown meant a complete cessation of in-person visits with parents and other family members, thereby compounding the trauma caused by family separation and the pandemic. Although in many situations, foster care agencies arranged video visits, these simply were no replacement for a hug or other in-person interaction with a parent, particularly for young children. Even as the world began to reopen, foster care agencies were slow to reinstate in-person visits. The pandemic also delayed access to court-ordered services such as substance abuse and mental health treatment, or parenting classes, which typically facilitate a parent's progress toward reunifying with a child in foster care. Compounding these problems was the lack of access to the court, with adjudicatory and review hearings being postponed, even once the court reopened for virtual hearings. This triple whammy of lack of contact, lack of services, and lack of court access has resulted in inordinate delays and obstacles for reunifying parents and children. This is why many advocates have called for a tolling of the federal timelines imposed by the Adoption and Safe Families Act, or ASFA, which state that if a child has been in foster care for 15 of the last 22 months, the state is mandated to move to termination of parental rights and adoption of that child, absent certain exceptions. While even prior to the pandemic, there had been a growing movement for ASFA repeal or reform, the pandemic has only underscored how unfair and arbitrary the 15-month timeline can be. There's also early data which is suggesting that the pandemic has exacerbated the already existing deep racial disparities in the child welfare system. Even prior to the pandemic, Black and Brown children are far and away disproportionately placed in foster care, less likely to receive needed services to remain at home, and less likely to reunify. And while fewer children have entered foster care during the pandemic, the rate of reunification has decreased significantly, which may widen that disparity. Ultimately, for so many families who rely on the family courts, the pandemic has created further obstacles to meaningful access to the courts, to needed legal assistance, and other resources, thereby compounding the existing challenges for these families. I suspect we'll be feeling the effects of these challenges for years to come, and I welcome questions and further discussion.
Thank you so much, Professor Katz, for your comments. Professor Ahrens, you are up next.
Thank you. And I am echoing everyone else. I'm so excited to be here and to be part of this conversation. And I'm especially glad that I get to go immediately after Professor Katz, who I think just pointed out the many ways in which the pandemic, these last 18 months have really negatively affected families involved in the family regulation system, which is what I will be calling it. It's also called the child welfare system. I'm, despite that, going to try to do what might be impossible here, which is to find something hopeful within all of this, and not just find something hopeful within COVID, but find something hopeful within COVID and the family regulation system together. So I think over the last several decades, there's been a growing recognition of the family regulation system of child welfare as a system designed and functioning to police, surveil, and separate Black families, poor families, and Latinx families. And there's also, along with that, been growing calls for abolition of that system, but those calls are very often dismissed and derided as unrealistic and probable kind of pie in the sky dreams. But I think that what COVID has given us is a real world example of what abolition might look like. And it's given us that through looking at the example of New York City, where COVID forced the shutdown in large measure of much of our very vast family regulation system. So in the city, which is where my research is focused, we've had the family regulation system shrink by almost half as far as the number of reports received, investigations initiated, and removals of children from their families. But even as it has shrunk that dramatically, we've seen that children have stayed just as safe at home. And that's not because of the family regulation system, that's because of its absence, and the fact that in its absence, families and communities have been able to support themselves through these growing, robust mutual aid networks, as well as the influx of government aid in the form of stimulus checks and now the child tax credit as well, that are giving families the autonomy and the resources to meet their own needs. So I'm going to spend most of my time here discussing what the family regulation system has looked like in New York during COVID. But before I do that, to kind of set the stage, I'll talk a little bit about what it looks like in, I guess, what we would call normal times. Although I think, the farther and farther we go into COVID, it is harder and harder to think about this distinction between pre and post. And maybe, that dichotomy is becoming less apparent, less important. But if we're going to look at how the family regulation system was operating in New York prior to March of 2020, what we had was a system where there were approximately 65,000 new investigations initiated each year. So those are calls received, which then result in a worker going to a family's home, usually with an unannounced visit, usually in the middle of the night, or they often schedule them 4 times when they believe the family will be home, which often means evening and late night visits. And during those visits, there are invasive searches of not just, every room in the family's home, looking in cabinets, asking children to be undressed, speaking with every member of the family. The sources of those investigations are largely from mandated reporters. So in any given year, about a quarter of them have come from school personnel in particular. And it's important to note that the allegations that are being addressed in or being raised with these reports are typically neglect, not abuse. So I think we have this conception of child abuse as kind of the pandemic, or well, I shouldn't use pandemic in this context, but the driving concern of this system. But in fact, its allegations of neglect are 70% of the reports received. So those are allegations like a child having inadequate food or clothing or shelter, or being left alone, or a child missing school, or perhaps concerns of the parent's substance use or mental health. So even with this vast net of 65,000 investigations initiated each year, the workers coming to the home, only about 35% of those investigations result in any sort of substantiation of the allegations. So for 65% of the families, we have this very invasive procedure that then finds nothing. But of those cases where something is substantiated, 8,000 children are in foster care in New York City, and there's another 7,000 or 8,000 cases which are not rooted to court and where children are not separated, but that are instead placed on a preventive services track, which are in theory voluntary services, but often offered to the family with the penalty of, if you do not agree to these services, then we will bring you to court. And in all, there are about 10,000 cases filed every year. And it's important, I think, one of the most important features, let's say, of this system is that 90% of children involved in it at every stage, from reports to court to foster care, are Black or Latinx. And that's in a city where only about 60% of our children are Black or Latinx. The investigations as well are heavily concentrated in the poorer neighborhoods. So even if you're controlling for race, you have poverty as the other big driver of investigations. And I think if you look at the overall numbers, you see that 1 in 3 Black and Latinx kids in New York City will have an investigation into their family over the course of their childhood. So I think it's fair to say that prior to COVID, ACS, which is the family regulation agency in the city, was an omnipresent feature in the lives of many poor Black and Latinx families, even as it was largely invisible to white families and to wealthier families who might live just a neighborhood or two away. But when COVID began in March of 2020, it resulted in immediate and seismic changes in how the system was run. So the 3 kind of big changes I will highlight is first that COVID resulted in the State Office of Children and Family Services recommending that caseworkers try to curtail their home visits and to do as much work as they can remotely. So in terms of those initial investigative visits, doing them by Zoom if they could, or making phone calls. And if they couldn't do that, then at least announcing beforehand to the family, making a call and saying, do you have, symptoms of COVID, let me do the safety check first. So the visits are no longer unannounced. months. The other immediate change was that with children out of schools, there was a much smaller amount of contact between children and mandated reporters. And then the final change was in the operation of family courts themselves. So the family courts in the city went from accepting allegations where the government was trying to place children in foster care or place the family under court order supervision to only accepting cases where they were trying to place a child in foster care. So all of this resulted in an immediate drop at every stage in the family court process. So we had a 40% reduction in the number of reports and investigations, as well as a similar drop in the referrals for those preventive voluntary services. There were also half as many new filings made in family court in this time. But what I want to especially underline is there were half as many filings. There were also half as many placements of children in foster care. So these are cases that the agency still was authorized to file. They were still empowered to go to court and petition for the removal of children from their families. But even so, ACS began requesting far fewer removals of children, which would seem to suggest that they were assessing more rigorously before they went to court whether they really needed to remove a child from their home and whether they could meet the legal standard for a removal. Even so, when they got to court, judges also began approving fewer removals. So we have both the front end of fewer being requested and the back end of the judges denying more of these requests, which would perhaps seem to be counterintuitive in that we would think that if the judges were only seeing kind of the worst of the worst cases, they would have, if anything, approve more removals rather than fewer. But what I have learned from speaking with both parents and with practitioners in family court in this period is that it seems that the judges were paying more attention than ever to one of the statutory factors that they have to consider, which is the harm to children of removal from their families, and paying special attention to, I think, what Professor Katz just spoke of, which is the fact that if children were placed in foster care, there was no guarantee that they could have any kind of contact with their parents. There was no guarantee of twice weekly visits or anything like that. It was this very real chance that a placement in foster care would mean a total severance of that parent-child relationship for the duration of the time that they were in foster care. This piece of data, this drop in placements in foster care, and then, as I will get to in a moment, the fact that there are no apparent rises in risk to children as a result of the fewer placements in foster care, I think really underlines an argument that parents and advocates in the city have been making for years, which is that ACS and the courts have not been using foster care, as they say, as a tool of last resort, but have instead been removing children who do not need to be removed in the past. So they have been using this tool to a degree beyond that necessary to actually keep children safe. And they are using it instead, out of a sense of frustration with parents or out of a sense that the parent is not complying in the way that they want them to, rather than fully limiting themselves to those cases where it meets the legal standard. So I want to talk now about when I say children have stayed just as safe during COVID, what that's based on. But before I get into the numbers, I also want to highlight that at the time I began writing this paper, I did not predict this would be the outcome, but the commissioner of the ACS, of the Administration for Children's Services, he testified at a city council hearing last summer. And his testimony as well was, our children are just as safe, and here are the metrics that he, the commissioner, is using to show that. So this is not, at this point, no longer my fringe position. This is the position of ACS itself as well. So the first big number is that there has been a drop in child fatalities in the city, and there has also been no change in kind of the breakdown of abuse versus neglect cases. So just kind of as a footnote, the fatalities in the child welfare system and family regulation are a tiny, tiny, tiny drop in the bucket, but they also are the kinds of cases that are typically driving policy. And they also are the cases that are the most difficult to avoid detection. So even if we're going to say children are locked away with their families out of the eyes of mandated reporters, something like a serious injury to a child, or God forbid the death of a child, that's going to be something that will come to someone's attention. But despite that, fatalities in the early months of COVID dropped by 25%. There also, per the commissioner of ACS, was no change in ER admission patterns. And as I just mentioned, there was no change in there being any sort of rise of abuse allegations as compared to neglect allegations. Moving to other metrics, we now also have been in COVID long enough that we are now coming to the point where children are going back into public life. So we're having more children in school in New York City now. We are fully in person for all of our public schools. So this means that children are now back under the surveillance of mandated reporters. But even with that, the number of reports has not surpassed the point that it was at pre-COVID. So it has begun to creep back up to what it was before, but there has not been any sort of rebound effect, no sort of higher number of reports that might indicate that there was a backlog of reports that now has to be made to make up for all those that went missed for the last year or so. And closely related to that, there also has been no change in the rate of substantiation of reports. So throughout from 2019 to now, the rate of substantiation has remained at approximately 35%, meaning that of the investigations that take place, only about 35% of them substantiate the allegations, find that there's any evidence to support them. So this is important, not just because it shows that there isn't now this, bolus of undetected abuse or neglect cases, as the commissioner called it, that is now being brought forward and that's being investigated and found to be valid. This is also significant because past studies have shown that if there are fewer reports of child welfare or to child welfare hotlines, then the reports and the investigations themselves become more accurate in that individual caseworkers have more time to devote to each individual investigation. So we might expect that if anything, the rate of substantiation might rise, but it has stayed completely steady throughout. So I want to turn now to what we might attribute this to. How did it happen that in this moment where everything was becoming increasingly difficult for families and for particularly Black, Latinx, and poor families, how did they seemingly manage to keep their children safe without this vast system that we have designed allegedly to do that purpose? I would argue that it's because we are allowing families and communities to care for their own children, and that we are giving them the resources to do that and the space to do that for the first time. So the two things that I would point to here are, on one hand, mutual aid, and on the other hand, government aid, but a very specific kind of government aid. So beginning with the mutual aid piece of that, what we have with mutual aid is this idea of solidarity and collective action rather than charity and saviorism and control. So it is community-based rather than top-down. And in New York City, in the first several months of COVID, these networks, some of which had already been in existence, some of which came into existence during COVID, collected and redistributed hundreds of thousands and up to millions of dollars in their neighborhoods. So that went to groceries, diapers, provisions like that. But there were also services being offered. So things like childcare, counseling, substance use. And this was in every borough in the city, obviously not just in the city, but my research is focused on the city itself. At the same time, we also had financial assistance from the government with fewer strings attached and with fewer tests of worthiness than we might have seen before. So initially that took the form of increased unemployment benefits and stimulus checks. Now we can also include in that the new child tax credit. But taken together, this is the largest transfer of wealth from the government to the people than compared to all other non-retirement programs combined. And this resulted in the early days of COVID, an actual drop in the rate of poverty. And if we look at studies of how people spent the money that they received from the government, we see that they spent it on things like rent and gas and the necessities that they had been unable to pay for previously, rather than, I think there's, the rhetoric of the welfare queen, and we can't just give people money because we don't know what they'll do with that. What this money, giving it to people without strings attached, allows them to do is spend it on the things that they think are important for their families and that they think are necessary for their families. I should also note that I don't want to present either these government programs or mutual aid networks as perfect or utopic creations. I think especially with the government aid, there are still some metrics of worthiness included. For example, undocumented immigrants were excluded, and it's more difficult in terms of jumping through hoops for people who didn't pay taxes in the past to receive these stimulus funds and all of that. And in terms of mutual aid, I think especially in gentrifying areas, gentrifying neighborhoods, there came to pass some of the same kind of hierarchical white dominated structures that you might see in more traditional nonprofits. But I think even with those caveats in mind, compared to existing government programs and compared to things like ACS's preventive services, which came accompanied with all of these hoops for families to jump through, and surveillance, and also kind of the stick of, if you don't do this, we will take action against you. These present an opportunity that does grant families more autonomy and more power to decide the best way forward for their families. So I think the question now is, how do we hold on to these gains as we move into this post-COVID era? And as I referenced before, the number of reports is now inching back up. The number of cases filed remains lower than it was in 2019, but we do have more children being placed in foster care than had been a year ago. I feel confident in saying that without large structural changes, we will resume business as usual kind of as soon as we are able to. ACS will go back to doing what it did before. I think in terms of what structural change might look like, I think one of the biggest reforms to be made is in the area of mandated reporters, and rethinking, one, who is a mandated reporter, and two, what they are mandated to report. And I think there's, a whole body of research well beyond what I will have time to talk about here about the role that bias plays in mandated reporting. There's also a body of research about the relationship, how it impacts the relationship between a school and a parent, for instance, if a parent knows that the school is a mandated reporter, and how that might negatively affect a child's education. I think as well, continuing this move away from the preventive services model and into this model of how do we truly prevent any contact with this system in the first place, in terms of giving families the resources up front so that they don't have to go to ACS, they don't have to have services ordered for them, or they don't have to be told, okay, well, we will give you, a bed for your child, but only if you're still going to allow us to come to your house every 2 weeks. What if we take the money that we are giving to the foster care system, that we are giving to the family regulation system, and infuse it in communities from the outset? And I think the final piece that I want to focus on is just this skepticism of the family regulation system and of the agency underlying it, ACS, and stop to move away from this mindset of focusing so much on the risk to children that they face if they stay with their families, as compared to the harm done to children by removing them from their families. There is, I think, a harm involved in every removal, or even less than a removal, the invasion of a government worker into a family's life. And yet I think that is very easy to kind of get lost in this fear for children's lives and this fear of what happens if the government doesn't intervene. So I think just in closing, I would be remiss not to mention, I recognize all of the last 18 months have been truly a traumatic time for this entire country, this entire world, but especially for Black, Latinx, and poor communities in the city and around the country. I think we are looking at the number I've continued to update in my paper is 700,000 deaths from COVID. When I started writing this in December, I think it was 400,000. The brunt of COVID is being felt by families in these neighborhoods and families who are not white. But I think if we can look at these 18 months as a rare opportunity, a rupture that made it impossible to kind of continue with business as usual, and that forced us all to reconsider the status quo in all areas of life, including child safety, then perhaps this time can also serve as a model of a more humane and a more equitable path forward that shows us that we need not destroy families and destroy communities in order to keep children safe. Thank you.
Thank you so much, Professor Ahrens. And finally, I'll turn it over to you, Professor Jocelyn.
Great. So I'm going to try to share my screen. Okay, great. And do you see just the slide? Yeah, great. Okay, great. So thanks so much to you, Lauren, for moderating our panel, to Liz, David, Emily, and everyone else who brought us together for this really important conversation. I'm really honored to be here with my co-panelists. So my remarks today focus on how the COVID pandemic has really underscored the urgent need to reform outdated and discriminatory parentage laws. So as we all know, since 2015, same-sex couples here in Pennsylvania and around the country have had access to marriage. But despite this important development, same-sex parent families, and most importantly, their children, remain vulnerable. And this is true because in many states, their parentage laws remain rooted in a gender hierarchical heterosexual model. So take the case of In Re AE, which was decided by a Texas intermediate court in 2017. The case involved a married lesbian couple who had a child together using assisted reproduction. Eventually, their relationship broke down and divorce proceedings were initiated. And in a divorce action, the non-birth spouse argued that just as a husband who had consented to his wife's insemination would be considered a parent of their child, she too should be recognized as a legal parent of their child. But the court in the case disagreed. The Texas Intermediate Court said that substituting the words spouse for the words husband and wife, the court said would amount to legislating from the bench, which is something the court said it declined to do. To be sure, other courts have reached contrary conclusions, but this decision is not a complete outlier. And actually, indeed, just a few weeks ago, the Idaho Supreme Court reached a very similar conclusion involving a child born to a lesbian couple. And here I want to pause for a moment just to make sure we all fully appreciate the impact of rulings like this, rulings that a person who is functioning as a parent to a child is not that child's legal parent. So one potential consequence is one that Anna was just talking about in a different context, which is that the child might be abruptly and permanently here, in this context, permanently cut off from one of their parents. And that is what happened in the AE case and what has happened in the Idaho case. These children actually may never see their parent again. And studies show that this kind of separation, maybe not surprisingly, causes really profound and lasting trauma for children. Moreover, if the person isn't recognized as a legal parent, it also typically means that the child is not entitled to a wide range of benefits and protections through that person. So, for example, a person who's not a legal parent typically can't be ordered to provide child support for the child. The child might not be entitled to protections like children's Social Security benefits if that person is injured or killed. To be clear, LGBT parents have faced these uncertainties and challenges for decades. This isn't new, but the COVID pandemic really further compounded the challenges and the stresses that these families face. And I'll share just one of endless number of examples that we could point to, but this is Elena and Denise. They are a married same-sex couple in Rhode Island. Elena is an emergency room doctor, and Denise also works in healthcare. And as a frontline worker, Elena contracted COVID early on before we had vaccines, before we had treatments that were effective. And as she worried about her own health, as she worried about the health of her spouse and the health of her two kids, she had the added worry about whether she, as a non-birth parent, would have the right to, for example, make medical decisions for their children if Denise was unable to, or in the worst case scenario, she worried about whether their children would have access to important benefits if she, the family's primary breadwinner, passed away. And her fears that she might become sick or pass away as a result of COVID, unfortunately, we know is not unfounded. So we now know that over 140,000 children in the US, or 1 in 500, have faced this very reality, the death of a primary caretaker. Or Ashley asked this in the chat, as she put it, for every 1 in 4 COVID deaths, one child has been left in the United States without a primary caretaker. And of course, many, many, many more kids have experienced the serious illness of a caretaker. Fortunately, there are efforts going on to try to minimize the gap between the law of parentage and the realities of families in the US today. And I want to talk about one of them, one that I was involved in, the Uniform Parentage Act, or UPA, of 2017. Lauren mentioned that I was the reporter for this act. And I want to talk about 4 of the important changes that are included in the act. So among other things, we eliminated unnecessary gender distinctions in the act. The act expands the ways of establishing parentage for non-biological parents. It updates the assisted reproduction provisions to better reflect developments in law and practice in the lives of families. And it expands the administrative process for establishing parentage. So that's the sort of big picture, and I'm going to drill down into the weeds for a minute. So a key goal of our revision process was to ensure that the Act applies equally and protects equally children of same-sex parents. And we started with the basics with terminology. So prior iterations of the Act had laid out distinct methods of establishing paternity on the one hand and maternity on the other. By contrast, the UPA of 2017 consolidates all of the methods under a single umbrella provision that applies equally without regard to gender. And then consistent with this basic principle, throughout the Act, specific means of establishing parentage were made gender neutral. So this is true of what's called a marital presumption. In earlier versions of the Act, and still today in many states, including Texas that we looked at earlier, and Pennsylvania, as you can see here, the rule is written in gendered terms, applying at least literally only to the husband of the woman who gave birth. So the UPA updates this presumption so that it applies equally to any spouse without regard to gender. But in some instances, just making the rules gender neutral isn't enough. And that's true because the rules in at least some states and at least some circumstances are premised on a model of reproductive biology and thus presume that both parents are genetically related to the child. But for most same-sex parent families, at least one of them is often not genetically related to the child. So in order to adequately protect these families, the rules must also allow for the recognition and protection of non-biological parents. To be clear, proof of biological connection is still a way of establishing parentage, but it's not the only way. There are other ways to establish parentage, including by evidence of having functioned as a parent to the child. So for example, under the Act, a person is entitled to a presumption of parentage if they have lived with the child since birth and held out the child as their child, the so-called holding out presumption. UPA also includes a way for a person to establish their parentage if they have come into the life of the child at some point after birth. This is the new de facto parent provision. As I mentioned, the UPA also expands and updates the rules applicable to children conceived through assisted reproduction, which, as Rebecca told us, is an increasingly common way for families, both same-sex and different sex and single parents, to have children. And in a very small number of states, including Pennsylvania, there just is no law at all governing the parentage of these kids. More commonly, states have statutes, but these statutes, at least by their literal language, only protect children born to married different sex couples. The UPA expands and updates the existing rules. It recognizes the parentage of all intended parents without regard to sex, sexual orientation, or importantly, marital status. It also sets forth clear rules about the status of people who provide gametes, sperm or egg, as well as people who act as surrogates. So to recap, the UPA creates or expands the routes by which a person, LGBT or not, can establish themselves to be a legal parent through marriage, through genetics, through function, through consent. And these advancements are really critically important to children, provide so many more children with stability and certainty about their families. But there's one more part of the UPA that I wanted to highlight before I close, and that is what I mentioned earlier, the expansion of the streamlined administrative process for establishing parentage. This is often referred to as voluntary acknowledgements of parentage, or VAPs. And here is a copy of the current Pennsylvania form. And essentially, if the parties complete these designated forms, which are distributed at all birthing centers and hospitals in the United States, the completed forms establish the party's parentage. And it's probably hard to see, but at the very bottom in the highlight, the completed form actually is conclusive evidence of paternity without the need to go to court or have any kind of court proceeding. And federal law actually provides that VAPs have the force of law and must be enforced and respected in all other states. And that's really important for families. It means that they have security about their family status, even as they move about the country and cross state lines. But in many states, including Pennsylvania, this process is only available to establish the parentage of a man who is claiming to be the child's genetic father. And so you can see that the form is only about paternity. It requires the birth mother and the birth father to sign the form. So in other words, men have access to this important, simple administrative process for establishing parentage. But in most states, women do not have access to this process. And so to remedy this form of discrimination, the UPA expands the classes of people who can use this process to include women, including same-sex spouses and same-sex intended parents. And I think actually this is one of the changes in the act. In lots of states, including Pennsylvania today, same-sex parents do have some means of achieving certainty and security about their families. It's through adoptions in most cases. But adoptions cost money. There are court fees. There are often attorney's fees, maybe home study fees. And in the end, the total may run in the thousands of dollars to get that adoption completed. And for many people, that means that while technically available, adoption is not practically available to those families. And even for the families who have the resources or who can gather together the resources, best case scenario, really, they might be able to complete that adoption when their child is maybe 1 or 2 years old, and they will have had to endure a year or two of not having certainty about their family. And particularly, and this is sort of echoing things that Sarah and Anna mentioned, particularly in the early days of the pandemic, that might not have been possible at all, as courts were shut down, as social workers were unavailable to complete home studies. In contrast to an adoption, again, this administrative process is free. Again, no lawyers are needed, no court appearance is needed. And in the overwhelming number of cases, these forms are filled out at the child's birth when the parents are in the hospital. And that means that the child's parentage can be established within days or weeks of the child's birth. And expanding access to this process, again, this free, accessible process that doesn't require courts or lawyers, is particularly important actually for same-sex parent families. Contrary to stereotypes about these families have higher levels of poverty than non-LGBT families. They are actually twice as likely as non-LGBT individuals to report household incomes near the poverty threshold. And they are disproportionately people of color as well. And so, I think as many of the remarks today have pointed out, a right in theory means little if it's not available in practice, and that's no less true in this context. So to sort of return to where we started, the pandemic has really brought into stark relief the stress, the uncertainty, the harm that can befall families when they are denied this really, really basic protection of family security, a protection that many different sex parent families take for granted. As I said, fortunately, we've got this model out there that can help states try to fill the gap. So far, we've had 6 states enact the UPA of 2017, and there actually is a bill pending in Pennsylvania, HB 115, which has been introduced by Representative Dan Miller to enact the UPA here in Pennsylvania. And in my little moment before I close, I actually just want to highlight the particular need for update and reform in Pennsylvania in particular. Pennsylvania's parentage scheme is incredibly bare bones, and it's actually based on a different uniform law, the Uniform Blood Test to Establish Paternity Act, which was promulgated almost 70 years ago in 1952. And was actually superseded and replaced about 50 years ago in 1973 by the first iteration of the Uniform Parentage Act. As I mentioned earlier, Pennsylvania is one of the few states in the country to lack any statutes at all governing children conceived through assisted reproduction. And these limited, really out-of-date provisions many parents, certainly LGBT parents, but many non-LGBT parents as well, and more importantly, their children in very precarious circumstances. And Pennsylvania has an opportunity to join many of its neighbors and to close some of these gaps and to have laws that better reflect and protect all of its families. So I look forward to your questions.
Thank you all so much for these fascinating presentations. And, you know, I'll just speak, I think for many of us, a lot of this material is very sensitive and can bring up a lot of reaction and emotion. And I think it's so important that we included this panel in today's discussion and that we are able to sort of bring to bear the humanity of this experience and the way that this year and a half, and as it continues to go, is exposing so many of the vulnerabilities in the systems that we have created. And so I thank you all so much for your presentations. And you know, one thing I was hoping to ask, and I have a lot of questions I would love to ask before I turn it over to the group, but is to talk a little bit about the community responses that we saw during this year. And Professor Ahrens, you alluded to this idea that when we gave families space and we gave them direct funding, right, we saw kind of remarkable outcomes in terms of safety for children and privacy for families. And I was curious if you would share a little bit more about these community responses of what you saw happening in New York. And Professor Katz, to the extent we saw this in Philadelphia too, I would love to hear about that.
Yeah, I'm glad to. And I think hopefully this will also get to one of the questions in the Q&A from, I think, Ashley Gindel, who was highlighting the number that Courtney had referenced as far as children who have lost parents during COVID. So I think a thing that I've thought a lot about both in practice and now kind of on this academic side is the lack of kind of respect, and I mean that in a kind of specific sense, that we give to poor families and to Black and Latinx and Native families in this country, that we don't respect them to kind of make arrangements for their own lives or to make decisions that make sense for their own families. So for example, this will all be unfortunately very New York based because that's where my geography is. But if I'm in New York and if I am in Harlem and a mother is attempting suicide, it becomes a problem for the state, and we're going to come in and try to remove her child from her and put that child in foster care. Whereas if a mother is attempting suicide on the Upper West Side, it becomes a family tragedy, and let's all figure out which grandparent can take the child and, you know, how we can kind of respect that family arrangement. So I think that one of the beauties of mutual aid is that it is elevating the networks that are already in place. And putting resources behind those networks and strengthening those networks rather than saying this is even a space that the government should be intervening in at all. So in New York, I think what that looked like was, I should also highlight, I think a part of the need for all of this arises from the complete absence of meaningful government support, especially in the early days of COVID. You know, I think I already went over time, but I didn't get into, you know, the food instability and lack of housing and all of that, right? But I think what we saw in New York early in COVID was grocery deliveries and diaper collections for neighbors, and just this building of, I think, support of pooling of resources within communities and then coordinated redistribution of those resources. So I think that was in many ways really heartening to see. The part that I'm a little bit kind of iffy about is I don't think that the kind of response should be this, there's no role for government and families should take care of themselves and we're going to let each community handle it on their own because that's what they want to do anyway, when that's completely overlooking that we as a country have spent, you know, 400 plus years creating this incredibly disparate society in which we have not let Black communities have the resources necessary to care for themselves. So I think that we can't just say mutual aid is the answer, community support is the answer. We have to also give families money, give communities money, and do that in a way that is respecting the autonomy of those communities and of those families. And so that's where I think the stimulus checks and now the child, to me, the child tax credit is kind of a remarkable thing that I cannot believe has happened, and, you know, is a rare kind of moment of just cure. This is a good thing that has happened in the last 18 months in terms of let's give families money and let's not say you can only use this for these certain products at the grocery store, as we see with food stamps, or that, you know, if you get this where you also have to do a back to work program, or it's just saying here is some money, you decide how to spend it. And I think that kind of goes to that idea of respecting the autonomy, respecting the networks and the communities and the support that already is in place.
Right. I would just echo that. I mean, I feel like, you know, for years, advocates have been saying and kind of sounding the alarm that family surveillance, you know, the child welfare system offers family surveillance and doesn't offer actual help. We're not actually helping families. We're just regulating them. We're surveilling them. And, you know, I mean, I was formerly a family defender. I know Anna was as well. Like how many of, you know, my clients over the years said to me, like, if they would just give me the money that they're giving the foster parent, I'd be able to take care of my own children. Like, this makes no sense. And reality is it's kind of a no-brainer for the actual participants, the actual families that are participating, that so much of what ends up being coming to the child welfare system is really just poverty, is really just the failures of the other social safety nets that we have. And that if we do provide people, you know, a basic income, if we do, you know, make sure that there's access to affordable housing and to, you know, accessible childcare, these are all things that would reduce our child welfare system to a much smaller government entity in the first place.
Well, I see that we're out of time, unfortunately, but thank you all so much for your incredible presentations today and for sharing all that you have with our community.
Okay, so thank you to everyone who has been with us today. To conclude this important discussion surrounding the future of reproductive rights, I would like to introduce Professor David Cohen from Drexel University Klein School of Law, whose Sex, Gender, in the Law class that I took last spring helped inspire the theme for today's program. Professor Cohen also currently serves on the board of directors for the Women's Law Project in Philadelphia and the National Abortion Care Network. Professor Cohen will lead a discussion that focuses on trends in reproductive health and rights through the lens of the pandemic and under the new conservative majority Supreme Court. So Professor Cohen, I'll turn it over to you.
Thank you so much, Emily, and good afternoon, everyone, and thank you for joining us for this incredible all-day event. The beauty of a Zoom event is not just that we can participate in a symposium without socks and shoes, but also that we can have hundreds of people participate more easily, some from all over the country. As someone who's been only tangentially involved with this symposium, I'm very grateful for everyone who's made it happen. The Drexel Law Review students who dreamed this up and put all the pieces in place, my colleague Liz Kokora for shepherding the idea from start to finish, Mary McGovern for all the administrative work involved with today, each and every one of our speakers and moderators for expanding our knowledge about these important topics, and all of the people who've attended this event from start to finish. I know that the CLE credits are a big attraction, but I'd like to think that the quality of this event is what kept you here all day long and what hopefully kept you from also billing your clients during the presentations or scrolling through Facebook and Twitter. I'm going to finish the day by offering some thoughts about what we're looking at into the future related to reproductive rights and justice. I want to preface my remarks by saying two things. First, some of this will overlap with some of the things you've heard already today because folks have already talked about parts of what we're looking at in the future. But I figure some of you might have missed those panelists and others, well, it's important enough to hear again. And second, my expertise is in abortion in the law. So much of what I'm going to say is focused on abortion as opposed to the other important issues you've heard about today. But I do think, though, that given the high profile nature of the abortion issue, we can pull important threads from what I'll say here and apply it to these other areas. When I'm done, we'll have time for some questions or discussion if folks want. So looking into the future, I'll start with the bad here. As we've heard already today, we are in very precarious times. Things were already bad over the past decade when we saw a huge uptick in anti-abortion legislation in quite radical ways. Ever since the Tea Party took over so many state legislatures in 2010, we saw them competing with one another. Who could be worse on the issue of abortion? The types of abortion restrictions they passed seemed almost endless. Minute regulation of abortion clinics, known as trap laws, extra hurdles patients had to jump through to get an abortion, such as waiting periods or unnecessary ultrasounds, restrictions on insurance coverage, both public and private, laws such as those Professor Melissa Murray talked about with us that tell people that certain reasons for choosing an abortion are illegal, restrictions on the type of abortions that can be performed, which literally have legislators telling doctors and other medical professionals what procedures they can and can't do. I could go on, and I did in a book I co-authored with Carol Jaffe last year about all the different sorts of abortion restrictions and their impact on patient care, especially their impact on poor people seeking abortions, women of color, and rural patients. Each of these restrictions has their own unique history, with some causing more trouble than others, and some being more likely to be unconstitutional and struck down by courts than others. But I'm not going to get into that now. Instead, I'll talk about the restrictions that have put us on a path that we're on now, abortion bans that are specifically designed to end legal abortion. And unfortunately, that path seems very likely at this point to end next year with Roe v. Wade being overturned. For a long time now, the multifaceted strategy of the anti-abortion movement has included, among many other things, two key components: passing more and more restrictions that they know will be challenged in court by pro-choice lawyers, while packing the court, especially the US Supreme Court, with judges who will look favorably on abortion restrictions when those cases reach them, and possibly then overturn Roe v. Wade. What we're seeing now is a result of their great success on both fronts. Though a quick aside here, before we give the anti-abortion movement too much credit, it's important to acknowledge that their strategy is coming to fruition because of a combination of movement organizing and some serious luck. They got lucky that Justice Thurgood Marshall got sick a year plus before Bill Clinton was elected, rather than after. That gave them Justice Clarence Thomas. They got lucky that Justice Sandra Day O'Connor's husband got sick and needed care during George Bush's term in office, not during Bill Clinton's or Barack Obama's. That gave them Sam Alito. They got lucky that Justice Antonin Scalia's sudden death occurred 9 months before the 2016 election, instead of maybe 19 months before the election, giving Senator Mitch McConnell a laughable but successful argument to push his replacement to the next president, giving them Neil Gorsuch. And they got lucky last year that Justice Ruth Bader Ginsburg passed away suddenly 45 days before the 2020 election, rather than 45 days afterwards. That gave them Justice Amy Coney Barrett. So before we give the anti-abortion too much credit for what's coming, let's remember the role happenstance has played in getting us where we are today. Okay, back to my main points about how this strategy of passing restrictions and packing the bench has worked over the past couple of years. Starting a few years ago, state legislatures became more and more aggressive in passing a particular type of restriction, gestational limit bans, and doing so earlier and earlier in pregnancy. For a while, 20-week bans were fashionable, according to the anti-abortion movement, but not backed by science. This was the point at which a fetus could feel pain. Some of these went into effect because providers in states didn't provide that late in pregnancy, or just didn't think it was worth their effort to challenge them. Others were struck down as unconstitutional because they were an infringement on pre-viability abortion. But the idea with these bans was to move the time in which someone could get an abortion back and challenge the constitutional guidepost of viability, which is about 23 or 24 weeks, not 20 weeks. But then states became even more aggressive and started passing bans on abortion even earlier in pregnancy. We saw a huge wave of 6-week bans at the beginning of 2019. Georgia, Ohio, Kentucky, Mississippi, Louisiana. Tennessee and South Carolina have since added 6-week bans, which, just to be clear, is really 2 weeks after a missed period and 4 weeks since conception, because 6 weeks in pregnancy terms is measured from the start of the last menstrual period. North Dakota and Iowa already had 6-week bans. North Dakota actually broke ground on this form of restriction in the early 2010s. And North Dakota and Iowa's had already been found unconstitutional when we saw this new wave. Other states went with different limits: Missouri at 8 weeks, Arkansas at 12, and even some at conception, like that law Alabama passed to wide media attention in early 2019. All of these bans suffered the fate we knew they would. They were found unconstitutional in federal court, even by some of the country's most conservative federal judges. But they were not completely useless for the anti-abortion movement. By passing so many of these early pregnancy abortion bans, these states brought the idea of banning abortion early in pregnancy into the mainstream. They used language like heartbeat ban, even though there is no fetal heart week at 6 weeks, just electrical impulses that an ultrasound machine converts to the sound of a heartbeat, just to please the people watching the images of a wanted pregnancy and want to hear the sounds that they think would go along with it. This heartbeat language pushed the public into thinking that there's a real live baby inside, one with a heart. So how can you go forward with an abortion when there's a beating heart? So even though those laws were unconstitutional and never took effect, the anti-abortion movement didn't stop continuing to try to pass them. But they also really realized that they needed to figure out a better way to actually try to implement these laws. And they found a willing guinea pig in Texas. Now, Texas is no stranger to extreme anti-abortion action. They passed HB 2 in 2012 over Wendy Davis's midnight filibuster that many of us watched, that eventually found its way to the Supreme Court and was struck down in Whole Woman's Health v. Hellerstedt in 2016. And early on in COVID, when states were dealing with the question of what is essential care that Professor Rebecca Feinberg just talked with us about, Texas's governor banned all non-essential medical procedures and did not exempt abortion. And unlike other states that did the same during the pandemic early on, and courts found the lack of exemption for abortion unconstitutional, in Texas, the back and forth with the district court and the Fifth Circuit resulted in multiple periods in which abortion was, early on in the pandemic, for a short period of time, unavailable in the state. In other words, the pandemic provided cover for the state to ban abortions, something it hadn't been able to do otherwise. But once Texas went back to regular life, and we know that happened in Texas much sooner than almost anywhere else in the country, it still wanted to restrict abortion, but no longer had the pandemic as cover. So when very few people were paying attention, earlier this year, Texas passed what everyone now knows as SB 8. SB 8 is just like these other early pregnancy bans in substance. It bans abortion after 6 weeks of pregnancy. So on the substance, this law is flatly unconstitutional, just like the other state bans at 6 weeks. However, as Professor Maya Mannion told us this morning, Texas created an abortion ban designed specifically to evade being found unconstitutional. And so far, it's worked exactly as planned. What SB 8 does that's original is it puts enforcement in the hands of everyone except for Texas government officials. So instead of Texas law enforcement or licensing departments making sure that doctors don't perform unlawful abortions, SB 8 says that private individuals, anyone, even if no connection to a patient, even if not in Texas, anyone can sue the person who performs the abortion, as well as anyone who aids and abets that abortion. And the lawsuit can be for $10,000 or more, and there's no exception for rape or incest. Providers in Texas sued to stop the law, but the law's unique features caused problems. Initially, a district court judge found the lawsuit could proceed, but before the judge could hold a preliminary injunction hearing, the Fifth Circuit stepped in and put the case on hold. That led to the emergency appeal to the Supreme Court the day before the law was scheduled to take effect. We heard nothing from the court the night of August 31st, as many of us watched with bated breath as the clock ticked over to midnight. So the law went into effect on September 1st. And just before midnight on September 1st, so 24 hours after the law had taken effect, the court finally gave us a 12-sentence, 1-paragraph, unsigned order, basically saying, sorry, this law is too complicated for us to figure out, so we're going to let it take effect for now. It was a 5-4 decision with a majority, an unsigned order, and Chief Justice Roberts joining the 3 liberals in dissent. With the Supreme Court's order refusing to do anything, SB 8 went into effect. And other than a 48-hour blip last week, we are now 45 days into almost no legal abortion in Texas. That blip came from a new lawsuit filed by the United States Justice Department against Texas. The hope with that lawsuit was that a suit filed by the United States could get around some of the sovereign immunity and jurisdictional issues that Professor Mannion told us about that make it difficult to bring a suit from the providers. After a hearing before the same judge who was scheduled to hear the provider's case back in August, last week, the judge issued a preliminary injunction stopping the law. So for 2 days, some abortion providers started providing abortion again. Though in Texas, which has a 24-hour waiting period, that would mean only 1 day of actual abortions. But 48 hours later, the Fifth Circuit put an emergency hold on the district court's ruling. So SB8 is back in effect. Both sides this week briefed the hold issued to the Fifth Circuit. And last night, the Fifth Circuit extended the stay until it hears oral argument in this case and the provider's case, neither of which has yet to be scheduled. Whenever that is, it'll be no surprise what this court, the Fifth Circuit, one of the most anti-abortion courts in the country, will do. In the meantime, as we've been in this symposium today, the DOJ announced it was going to file an emergency appeal to the Supreme Court. So we will await another opportunity for the court to step in or punt again on SB8. So as the legal wrangling goes back and forth, but all with the law in effect, what does this mean in Texas? What it means is that all abortion providers are following the law, and many are not doing any abortions at all. Lots of people have called for civil disobedience, with abortion providers daring people to sue them. However, so far, except for one doctor who admitted to doing one unlawful abortion to spur a test case, doctors and clinics have feared lawsuits and not challenged the law. Now, the fear is not rooted in the $10,000 fine, but rather the professional consequences from licensing boards and malpractice insurers of being sued, especially since doctors in Texas also often provide abortions in other states and could lose those licenses with too many Texas lawsuits on their records. And many clinics aren't doing abortions at all, let alone not even earlier than 6 weeks, because there just aren't that many to do. Estimates are that 10 to 15% of abortions take place at 6 weeks or less, which means it's hard to run a medical office with so few patients. For Texans, this means that unless you are completely on top of timing and signs from your body, getting an abortion is not possible in the state. So that means one of three things: travel to another state to get an abortion, illegally obtain abortion pills to self-manage your abortion, or carry your pregnancy to term. When these are the options, we know what will happen. The most privileged people who have access to money, transportation, support, and time will be able to go to another state to get an abortion or find ways, as Farah Diaz-Teo told us about this morning, to surreptitiously self-manage their abortion without risk of being prosecuted. Everyone else will have to sacrifice to obtain an abortion, risk law enforcement or immigration checkpoints while traveling long distances, raise suspicion, especially for patients of color, with their doctor or other medical professionals about what they're doing, or carry their pregnancy to term against their will. And from the Turnaway study, the massive multi-year study that told us, that looked into what happens to people who want an abortion but aren't able to get one, we know that people who carry a pregnancy to term when they were denied a wanted abortion suffer emotionally, physically, financially, and in their relationships. In other words, Texas is showing us what a world without nationwide legal abortion looks like. And that's even before Roe is overturned, something that is looking more and more likely with each passing day. On December 1st, the Supreme Court is going to hear the case of Dobbs v. Jackson Women's Health Organization, which multiple folks talked about with us already today. This case will review the constitutionality of Mississippi's ban on abortion at 15 weeks, the lone remaining clinic in the state, which does abortions only up to 16 weeks, challenged the law. And the lower courts, even the rabidly anti-abortion Fifth Circuit, struck it down as unconstitutional. But the Supreme Court, after Amy Coney Barrett replaced Ruth Bader Ginsburg to form a solid 6-3 conservative court because of the appointments I talked about earlier, took the case. Most people believe the case presents a direct challenge to Roe and Planned Parenthood v. Casey, because this ban is long before viability. So the only way to uphold it will be to radically change Roe and Casey, if not overrule them. Until the Supreme Court refused to intervene in Texas, I was in the camp that figured there was a 50-50 chance that the court would use Dobbs to overrule Roe. I thought it was unlikely they would uphold the law, but that they would find they would very possibly find some way to craft an exception, maybe because the clinic in the state only does a small number of procedures actually impacted by the law. However, after September 1st and the court's order regarding SB 8, I'm firmly in the camp that thinks this court is going to overturn Roe and do so explicitly. The proof to me is how they treated the right to abortion in the Texas case. If they cared at all about the constitutional right at issue, they would have stopped SB 8 in its tracks. Just imagine if a law came before the court that had the same civil enforcement mechanism as SB 8, but instead authorized suing anyone who engaged in a gun sale or provided Catholic school education. There is no doubt whatsoever that this court would have enjoined that law immediately. However, by letting SB 8 take effect, the court sent a crystal clear message what it thinks of the right to abortion. 5 justices don't think it's worthy of respect, and that clever legal tricks can circumvent its protection. In other words, 5 justices simply don't think it's a constitutional right. At this point, I foresee Dobbs putting the formal nail in the coffin of Roe. That's scary enough, but looking deeper into the case shows an even more frightening prospect around the corner. As our keynote speaker, Professor Murray, has pointed out on social media and on her incredible podcast, Strict Scrutiny, that as I said earlier, everyone should be listening to. Among the amicus briefs filed in the Dobbs case is one by Texas Right to Life. That brief asked the court not just to overrule Roe. It doesn't stop there. It also asked the court to overrule Obergefell v. Hodges, the same-sex marriage case, and Lawrence v. Texas, the same-sex sexual activity case. The brief states, these rights, like the right to abortion in Roe, are judicial concoctions, and there is no other source of law that can be invoked to salvage their existence. And the brief doesn't stop with those cases. It also hints that it wants the court to reach all the way back to overrule Griswold v. Connecticut, the contraception case from 1965. In other words, the far-right agenda is laid bare in this brief for the court to overrule all privacy rights associated with procreation, family, sexuality, intimate relationships. In their place, there is no doubt that these same groups would want the court to vigorously protect private enterprise more than current jurisprudence does, the lost constitution as they call it, and to extend religious rights beyond how they are currently recognized. Last term, amidst a winning run for groups claiming religious exemptions to general laws, the court recognized an exception for foster care placement here in Philadelphia, allowing Catholic social services to continue to contract with the city, even though it refuses to place kids with gay individuals. More religious exemption cases are surely coming to the court, and they will certainly carve out more and more exceptions related to all of the topics talked about today. And you can also count on eventually these same groups asking the court to find a constitutional right to life for fetuses, thus trying not just to allow states to ban abortion, but to force a nationwide ban on abortion on the entire country. Dobbs and its surrounding legal efforts show us a pretty clear attempt to engraft a pro-business Christian nationalism onto our constitutional order, and the movement just may have found the right combination of 5 justices who will go along with them in that quest. So that's a lot, and that's depressing, and it's a depressing look into the future. Without trying to sugarcoat what is really a rancid sandwich here, I want to spend the second half of my talk trying to convince you that it's not all doom and gloom. And I've got 4 reasons for you. First, there is great opportunity to learn from the pandemic over the past 18 months in trying to improve reproductive health, rights, and justice. We've heard a few examples of this today, like how Professor Anna Ahrens told us about just now in thinking about the various lessons we can learn from how New York City kids were safer during the pandemic. Earlier today, Jen Groves told us that clinics developed evidence-based ways to reduce touches with patients, including through telemedicine and remote delivery of abortion pills. And as Dean Rachel Rebouchet pointed out, the Biden administration is, as we speak, reconsidering restrictions on who can administer abortion pills. They were eventually lifted because of the pandemic, but once it is over, the hope is that these restrictions are permanently abolished so that patients can get these pills from places other than at a clinic, including the mail. This will only help with patient access to abortion in states where this is allowed, and hopefully we learn from the pandemic and improve going forward. We saw the same thing, as my Women's Law Project colleague Christine Castro told us this morning, with judicial bypass proceedings that have taken place during the pandemic. As she told us, some places have started doing these hearings via video because of the pandemic. If this can be carried forward once the pandemic ends, that will greatly improve access for minors who would no longer have to leave their house for the hearing and possibly raise the suspicion of their parents. Or they won't have to travel to a place far from their school, missing more school than necessary. This is another innovation that would greatly improve access for marginalized populations if we learn from the past 18 months. And other innovations Dean Rebouchet told us about around online availability of abortion pills during the pandemic should also continue and expand in the afterworld. More people are learning about and accessing abortion pills, and the improvements in the information around them and their delivery via internet providers or pharmacies is a positive development from this pandemic that no one can ignore. Not only does abortion by pill at home make some people feel safer during a pandemic, it also decreases need for travel and the complications associated with it, which is a serious problem for people living in states with few clinics and long distances between them. Second, we've seen the beginning of the effect of mass attention and mobilization around the issue of reproductive health, rights, and justice. With the marches earlier this month, people are beginning to take to the streets to demand reproductive rights specifically. I predict this call will only get more intense as the Supreme Court acts and the situation becomes more dire. Will this change anything at the court? Like Professor Murray, I sure hope so, but maybe not. But even so, can it influence politics in other ways? Absolutely. It can put pressure on a pro-choice administration like the Biden administration to do more. It can also change the course of the midterm elections next November and impact other state and local elections, like the upcoming election here in Pennsylvania for a Supreme Court justice, which everyone here in Pennsylvania needs to vote in. If you've been in one of my classes, you've heard me say, here in Pennsylvania, you have to vote twice a year, every year, or you're doing it wrong. So hopefully these kinds of things improve people's concerns around elections. This mass mobilization also has the possibility of forming a broad coalition on topics beyond just abortion. Roe captures headlines, but the growing concerns of reproductive justice are being woven into the framework of how people talk about these issues, especially younger people. Racial equity, gender justice, birth justice, class awareness. These things are becoming more and more a part of the mainstream reproductive rights movement. There's clearly more work to be done here to eradicate white supremacy and other ills from the movement, a lot more work. But the shift in how people talk about these issues is real. And when you combine abortion with talking about birth and child rearing and families, as well as the environment and criminal justice reform and immigration, you appeal to more and more people to realize that all of this is about self-determination and uplifting the people who are most impacted by oppressive government policies. And from there, you can build more support for the rights we've talked about today, while also expanding everyone's focus to issues that matter beyond those we're talking about today. This increased attention from the public building a more active movement can also translate to more direct activism, which is what we're going to need in the coming years as we deal with these big steps backwards. After Alabama passed its abortion ban at conception in 2019, millions of dollars in donations flowed to the state's abortion fund. The fund used this money not only to help pay for people's abortions who couldn't afford it, but also to buy one of the state's abortion clinics and to reimagine service delivery for the patients the clinic served. In Texas, with Texas shutting down abortion for most patients, volunteers have stepped up to provide practical support, driving patients across borders, watching their kids while they are away, housing them overnight. These practical support networks exist all over the country, and in the coming years are going to need more and more people volunteering with them. The intense focus on the issue right now means that there will hopefully be a steady stream of volunteers committed to helping people hurt the most by these policies. Third, while things are looking bleak at the US Supreme Court and in states like Texas and Mississippi, There are other states and local governments that look very different, and we can learn from them. Indra Lucero this morning talked about the birth equity bill in Colorado as a possible test bill for other states. On abortion, look no further than next door in New Jersey, where 2 days ago, the governor approved new regulations that lifted the state's ban on abortions in doctors' offices after 14 weeks, and with even greater impact, allowed the state's nurses, physician's assistants, and midwives to perform abortions. These new rules will take effect in the coming months and will open up abortion access across the state. And if the state passes its Reproductive Freedom Act later this year, the state will cement abortion rights into law and get rid of other needless regulations that impact service delivery. We see the same in other states, like in Maine. In 2019, after the people voted for a pro-choice governor after 8 years of one of the worst, most racist governors in the country, the state legislature took 2 incredible proactive steps to increase abortion access. The state lifted its ban on Medicaid coverage of abortion and, like New Jersey this week, allowed nurses and physician assistants to perform abortions. In a sparsely populated, poor, rural state like Maine, these 2 laws have radically changed how patients access abortion in the state. And then across the country in California, we're seeing some really interesting innovation there. California already had some of the most liberal reproductive health laws in the country, but the state has been expanding access even more. A bill signed last week will require public schools, grades 6 through 12, community college, and the state university system to provide free menstrual products and restrooms. And a bill signed 2 years ago requires all public universities to provide access to abortion pills on campus. Here in Pennsylvania, we don't have a legislature that's going to do any of these things, quite the opposite, in fact, but we do have a case pending in the state Supreme Court that might increase abortion access. After mobilization from abortion rights groups and unions in 2015, the state Supreme Court flipped to a majority Democratic court for the first time in decades. As a result, the court has begun to lead the way among state Supreme Courts on issues related to gerrymandering, environmental justice, equitable education funding, and criminal justice reform, just to name a few areas. In a case that will be heard early next year, I, along with attorneys from the Women's Law Project, including Christine Castro, who you heard from this morning, Planned Parenthood, and the law firm Troutman Pepper, represent almost all of the freestanding clinics in the state, challenging the state's ban on Medicaid funding for abortion. We filed our brief with the court 2 days ago, asking the court to rule that under the State Equal Rights Amendment, the Medicaid funding ban is an unconstitutional form of sex discrimination. We also asked the court to rule that abortion is a fundamental right in Pennsylvania and that funding pregnancy care, but not abortion care, is an unconstitutional burden on that right. All of this is under the state constitution. So whether the US Supreme Court upholds Roe or not is irrelevant. Given the precarious situation at the US Supreme Court, more and more advocates are going to look to state courts for protection of the rights that we've talked about today. Obviously, not all are going to protect these rights, but there are going to be surprises, like the Supreme Court of Kansas, yes, deep red Kansas, 2 years ago, that in a 200-page opinion found a constitutional right to abortion under its state constitution, protecting abortion rights in that state regardless of Roe. Victories like this are not set in stone and have to be protected from recall efforts against state justices, but they show that there is promise in state law when federal law fails, even in some really conservative states. And it's not just states, as local governments can get into the act too. New York City, Austin, and just last month, Portland have sent city funds to abortion funds, which help patients with the cost of abortion. But it's not just abortion. St. Louis in deep red Missouri passed the Reproductive Health Non-Discrimination Ordinance in 2017, which protects people in the city from discrimination for any reproductive health decision. And in 2019, St. Louis passed a bill ensuring access to quality prenatal and postpartum health care, nutritious food, and tampons or pads for incarcerated people. All of these things happening at the local and state level are happening because advocates are being proactive rather than just reactive. Advocates are looking at how their states or cities can improve access to care, not relying on the Supreme Court to guarantee it. They understand the importance of electoral politics, not just judicial opinions, to the cause of reproductive justice. They know to form coalitions like abortion rights and labor in Pennsylvania that flipped the Supreme Court in 2015, to win at the polls and impact abortion and reproductive rights policy for years to come. This won't solve the problem of some states completely banning abortion once Roe is overturned, but it will increase access and promote reproductive autonomy in key locations around the country that hopefully are accessible enough to people in restrictive locations. Finally, necessity is the mother of invention, or radical imagination, as Marie Carmen Farmer said this morning. And hopefully this dire situation we find ourselves in will push the reproductive rights and justice movement to try new things and promote creative, bold ideas. And to push legislators, federal, state, and local, to put their money where their mouth is and actually do something about reproductive rights and justice, rather than just take money from Planned Parenthood and Emily's List when they're campaigning, but not doing anything once in office to push the agenda forward. And here's where I think our side really needs to take a few pages from the anti-abortion movement's playbook. For decades, they have tried almost anything they could to rid the country of legal abortion. They passed laws they knew would be challenged in court and found unconstitutional, but they did it anyway. They knew the media would portray them as extremists, but they acted anyway. They riled up their base around abortion, knowing that party moderates might not agree with them, but they did it anyway. They created fictional terms like partial birth abortion and heartbeat ban that they knew were not based in science, but they did it anyway. I'm not saying that our side should resort to lying or unethical or harmful behavior, but we have to be willing to think creatively and take risks. Look at SB 8 in Texas. The enforcement mechanism was thought up by a lawyer, Jonathan Mitchell, who proposed something like it in a law review article in 2018. From there, cities in Texas tried out his model to ban abortions in city limits. And with that success, they took this interesting new idea bigger to the Texas legislature. And now we have SB 8 wreaking havoc for patients in Texas. The lesson here should be obvious. In our arsenal, we have to also have creative, clever attempts to mold the law in our favor. And we have to risk failure. No doubt Mitchell and the Texas legislature knew that when they passed this law, there was a serious possibility it would be struck down as unconstitutional. But they didn't let that stop them, as their strategy is to try lots of things and see what sticks. If it's not SB 8, then maybe it's something else, like the 15-week ban in Mississippi. Our side needs to take risks with laws and ideas that may or may not work as well. We can't lawyer ideas to death ahead of time and foreclose possibilities before they see the light of day. We need to think creatively and then push our politicians to follow the anti-abortion playbook and act, even if there is doubt about what the ultimate outcome will be. For instance, a few ideas in that vein. What about if Roe is overturned, the FDA not just approving the safety of abortion pills being available outside a clinic, but taking a step further and prohibiting states from banning access to abortion pills. After all, federal law preempts state law, so maybe the FDA can preempt state bans on abortion, at least with pills. Now, I know that preemption law has all sorts of complications, especially with the FDA, but shouldn't this pro-choice administration try? Or along the same lines, what about the US Postal Service, a federal agency, saying that abortion pills can be sent through the mail so that states with policies to the contrary are preempted? In a different vein, but related, what about leasing federal property to abortion clinics so that states have to come onto federal land to arrest abortion providers? Or a different Postal Service regulation saying that people who receive pills through the mail are permitted to take those pills on post office ground, even if a state prohibits abortion. What about pro-choice states passing SB 8 style laws, allowing lawsuits against people who harass patients outside clinics, or people who use fake clinics to deceive patients seeking abortion? I could go on, but the point should be clear. I have no doubt that if we take our cautious lawyer hats off and put our creative, bold, push the envelope lawyer hats on, we can come up with all sorts of interesting strategies to protect abortion access in a hostile environment. And when we do, we need to push for them to become law, rather than negotiate against ourselves and convince ourselves ahead of time that they are wrong for all sorts of reasons. We have to try. The crisis we are facing makes it a necessity, and hopefully more and more activists, strategists, politicians, and movement players will look at the landscape now and see that we have no other choice. So the road ahead is going to be tough, no doubt about it. Things could get much, much worse, and possibly really soon. But the hope here is that dire straits create an opportunity for fighting back in new and interesting ways. And maybe if that happens, we can eventually build a more just world that does an even better job of protecting reproductive health, rights, justice, and freedom than the one we have now. Thank you, everyone. I look forward to questions or discussion, and hope you all had a great day.
Thank you, Professor Cohen. That was really enlightening. I guess I will kick off with a couple of questions, and then I'm sure we will get some more through the chat. But just for starters, Professor Mannion answered this briefly in the Q&A function, but I was hoping maybe you could elaborate on, with SB 8 and standing, how do private unaffected citizens have standing to sue under SB 8?
So the interesting thing, or one of the many interesting things about SB 8 is that basically the Texas legislature has said, just by virtue of us passing the law, you have standing. Texas doesn't have to follow federal jurisprudence about Article 3 standing. So anything you've learned in law school about Article 3 doesn't necessarily apply in Texas. Texas can make its own rules. From people who I know who have studied Texas standing rules, they do tend to follow what the US federal courts do. But there's always the question of whether the legislature can just directly confer standing on people, regardless of what the background principles of standing are. Now, I have no doubt that if we see any of these cases in Texas going forward, the actual lawsuits against the people providing abortion and aiding and abetting, not the lawsuits challenging the law ahead of time. But if we see any of these lawsuits moving forward, that part of the legal strategy will be to challenge standing, to say that these people have no standing. But whether the Texas courts say that this is allowed or not under Texas law is up in the air. And the Texas courts, state Supreme Court, is probably just as conservative as the Fifth Circuit in terms of being anti-abortion. So I think most people think that likely the Texas Supreme Court would say that the legislature can just legislatively grant standing to anyone. But I'm not going to say that is a definite outcome of the case. Maybe they'll find a way to say that this law increases standing beyond what is allowed under the Texas Constitution and get rid of the law that way. But that's far down the line, because we need an actual lawsuit against a provider and then appealed up through the Texas appeal process.
Okay, kind of along the same lines with regards to SB 8, can you explain the Supreme Court's use of the shadow docket to make such a huge decision, like allowing SB 8 to go into effect, essentially doing away with a constitutional right?
So the shadow docket was a term created by a law professor, a conservative law professor, Will Baud, about 5 years ago, to acknowledge or recognize that the court has a bunch of cases on its docket that it doesn't get full briefing, doesn't have full oral argument, and instead issues orders, usually on an emergency basis, in cases that are quite consequential. And another professor, Steve Vladeck in Texas, and I strongly encourage people to follow him on Twitter, because he has all the most up-to-date information about the Supreme Court, SB 8, and the shadow docket. Professor Vladeck has been tracking the shadow docket over the past 3-4 years. And what he's seen is that the court, I mean, there always has to be a shadow docket at the Supreme Court, because there are always going to be cases that require emergency attention. But what he has documented is that the court has increased the number of shadow docket cases and used them in quite consequential matters, including last year, for instance, all of the COVID regulations around the country that were being challenged as violations of religious liberty. And the Supreme Court, before Amy Coney Barrett joined the court, had tended to allow states to shut down entities generally, and in that ambit capture religious organizations. But once Amy Coney Barrett joined the court, it started flipping and issued shadow docket ruling after shadow docket ruling in which they found that COVID restrictions had to give way to religious entities. And so this court, what Professor Vladeck has found is that this court has used the shadow docket to inscribe conservative legal victories onto the court without full briefing, without full argument. So on issues of religious exemptions, death penalty, immigration, eviction exceptions during the pandemic, and now with this abortion case. So it is not out of character for this court to use the shadow docket in these ways. I think a lot of people have been very critical of this, saying that these shadow docket rulings deprive the parties of full briefing, deprive the court of full understanding of the case, and put the court in this position where they're issuing really important rulings in such a hurried manner. And that's what we saw with SB 8 on September 1st, and probably what we're going to see again. As I mentioned when I was talking, today the Justice Department said they were going to appeal the Fifth Circuit's order from last night to the Supreme Court. I have no doubt they're going to file their brief in the next day or two, and then Texas will file its brief early next week, and then the case will be in the Supreme Court's hands. And so maybe sometime late next week, we are going to get another shadow docket ruling from the Supreme Court on SB 8. And will the different jurisdictional issues related to the United States suing versus providers suing change the 5-4 court that approved SB 8 and flip it to a 5-4 court that puts SB 8 on hold? I'm not going to hold my breath for that outcome, but certainly that is a possibility. But these emergency cases are what are presenting the court with this shadow docket phenomenon, or this increased shadow docket phenomenon.
So as the court tackles Dobbs and similar cases, this is a question from the Q&A. Do you anticipate any sorts of compromises on the court? So reducing the viability period to 6 weeks like SB 8, or something like that, in which the court could reach a deal without fully overturning Roe?
I mean, anything's possible with the justices. They can create doctrine out of thin air, and they can create compromise. And we've seen that before, and it's not at all out of the ordinary, not out of the realm of possibility here. I think it's very unlikely for a couple reasons. One, I think they have been, first, they've been put on the court for a particular reason. The 3 Trump justices, Gorsuch, Kavanaugh, and Barrett, were put on the court by a president who said that I am putting justices on the court who will, quote unquote, automatically overturn Roe v. Wade. This was his promise. And obviously justices can't automatically overturn a case, so he didn't know what he was talking about there. But I'm pretty sure that he put them on the court for that reason. And I think that we would be foolish to think that they are not likely to deliver on that promise. So that's one reason. 2, finding a compromise position that brings viability back, I think would be really hard to do with any principle. Now, I would certainly welcome a decision that says 15-week can be, a state cannot go before 15 weeks rather than overturning Roe entirely, because that would still leave open about 93% of abortions in the country. But it's hard to find a principle, a legal principle that will allow them to say 6 weeks, 15 weeks, 20 weeks. None of it would really make sense. And I think both conservative and liberal scholars and advocates agree that pushing back viability, A, would not be supported by medical science. Viability is 23 or 24 weeks. That hasn't changed. And it's not supported by any doctrine that you can come up with other than maybe just the doctrine of 5, which is that if 5 justices say it, it is the law of the land. So that's why I'm not going to foreclose that option. 5 say it, that's the rule. But I think it's not likely because I think it would be difficult.
And I know you said that you're expertise is centered on abortion, but I know that you're also a constitutional law professor. So this is a question from the chat that I thought was particularly interesting. Sophia asks about how SB 8 could be extended to other medical choices. So for example, the COVID vaccine. If a state could give private citizens a cause of action for abortion, what would stop another state from doing that for the vaccine?
So I guess let me think this through, so that there would be a private cause of action to sue anyone who provides the vaccine, or maybe the flip, a private cause of action to sue anyone who doesn't get the vaccine. I think the answer to this question is that the fear is that this SB 8 style of enforcement could catch on and be used to really squash or quash constitutional rights in any realm. I mean, I used the example when I was speaking of gun rights, or free speech rights, or religious exercise rights. What's to stop a state that is just as anti-gun as Texas is anti-abortion from passing a law that literally takes every word from SB 8, except instead of says provides an abortion, says sells a gun. So we're not going to, sue the person who buys the gun. We're going to sue anyone who sells the gun, and anyone who aids and abets the selling of a gun. $10,000, no exceptions, no state involvement. I mean, if SB 8 gets around review like it has so far, then this other law should also get around review. And the law about SB 8 style law around coronavirus vaccine should get around review. I think that the concern is that this model under SB 8 completely upends so much of what we know about how the justice and legal system work, that if the courts don't do anything to stop it, it could catch on. And we've already seen states introduce copycat laws, just SB 8 laws on abortion, Florida in particular. But I'm waiting for a blue state or a blue city to introduce an SB 8 style law like the ones I talked about.
That's really interesting. And this question goes back to Roe. So after Roe is overturned, is there any chance of turning back the clock and reinstating the constitutional right to abortion?
Yeah, absolutely. If we win elections and get justices on the Supreme Court who are willing to do exactly what it seems like the justices are going to do in Dobbs, then I think that absolutely we can go back. I have been skeptical of the arguments around Roe on stare decisis. I think we should be defending Roe on its merits, because if Roe is overturned, suddenly I don't care about stare decisis. I want that new case overturned. And there are a lot of cases decided by the Roberts Court and the Rehnquist Court and lots of other courts that I want overturned. And I think that if we on the left are have too much of an homage to stare decisis, it's going to burn us in the long run. Because if Dobbs is decided the way it is in June, that I expect it to, I absolutely will be, along with a lot of people that you heard from today, arguing that we need to get pro-choice justices replacing conservative justices when they retire, and then those pro-choice justices, to use the words of President Trump, automatically overturn Dobbs and do it immediately without a special justification, without waiting for a period of time to see if Dobbs is effective or not. Overturn it, because this is politics and this is a fight. This is millions of people's life and health at risk. And if we talk too much about stare decisis, I think we ignore the reality of what we might be facing down the line.
And this question kind of goes to that. This is from Jen in the Q&A chat. She asks, has the Supreme Court ever spoken to the exceptions that states have sometimes carved out for abortion, like rape, incest, etc.? And do you think that if the Supreme Court overturns Roe v. Wade, they will speak to these exceptions at all, or avoid them altogether and let states decide?
That's a good question. So in Roe and Casey, the court has talked about health exceptions, saying that there needs to be, when we do this balance under strict scrutiny, there needs to be health exceptions for the woman's health. States have been the ones who have been putting in these rape and incest restrictions, and to the best of my knowledge, the court has not said anything about them being constitutionally required. It could go to a rational basis review. You could say that a ban on all abortions under all contexts fails rational basis review. But I think it would be hard for this court to say that if they're going as far as overturning Roe. I don't think they would. And I think there's actually plenty of anti-abortion activists and legislators, lawyers, academics who see the exceptions for rape and incest as completely inconsistent with a right to life. If a fetus has a right to life, if it is a person that has constitutional rights, it doesn't matter how it was conceived, because that entity has a right. And so there are plenty of anti-abortion activists who are against exceptions for rape and incest because they think they're inconsistent with their argument for right to life. I think we saw that in SB 8. SB 8 doesn't have exceptions. And I think we're going to see more laws without those exceptions.
And this question is from Madison. Madison asks, in light of the future of Roe v. Wade looking grim, what do you think is the best way to get involved in advocating for abortion rights and access?
So I think that unless you have incredible resources and access, you have to, this is the old environmental slogan, to think globally, nationally, act locally. There's a lot that can be done locally in terms of improving access. There are abortion funds all over the country that need volunteers and need support. There are practical support networks all over the country that need volunteers, they need support. There are abortion clinics who need escorts, to protect patients from the anti-abortion extremists who are outside clinics. And so those kinds of things you can do right where you live, almost no matter where you live, to help out. And that's real activism, on the ground activism that people can do tomorrow. And then there's voting. I mean, I can't stress it enough. A lot of people think that voting is once every 4 years, or for really active vote, they think they're active when it's once every 2 years, but it's not. Like I said, here in Pennsylvania, it's twice a year, every year. If you don't have a plan, if all the Pennsylvania people here, if you don't have a plan to vote on November 2nd, you are doing everything wrong, because you need to vote no matter if it's one person on the ballot, and there will always be at least one person on the ballot in Pennsylvania, or a whole slate of people on the ballot. There's an election November 2nd. Familiarize yourself with who's on the ballot and get out there and vote, and tell everyone you know. For people who are in my classes, I've said I would fail you if I could for not voting, because you have completely missed the understanding of constitutional law if you're not out there voting. Now, I can't fail students for not voting, so don't worry about that. But I want to, because it's that important. The things that I talked about in St. Louis and Portland and Austin and New York City and Kansas and California and Maine and Pennsylvania all happened because of electoral politics. When electoral politics is something we leave to once every 4 years or once every 2 years, we lose the opportunity in states and local government to improve abortion access. And I know a lot of people like to look to Washington, D.C. and look to the Supreme Court, but the reality is there's very little that most of us can do to impact those things, other than voting and speaking up, but have real, that's something that you need a lot of access and a lot of money to change. But you don't need a lot of access and a lot of money to impact your local government or your local clinic or your local environment. And so people should really be looking there. And I'm sure any of the people who are part of the panels today could point you in directions if you reach out to them.
Great. So Professor Mannion asks, how do you think where the court is going with reproductive rights relates to legal issues around voting rights, such as laws restricting access to the ballot, gerrymandering, and the court's gutting of the VRA?
I think that the connection is just so clear when we look at Texas. Texas has really gerrymandered its legislature. And so even though Texas is I wouldn't yet call it purple, but it's getting there as a state. Its legislature is overwhelmingly anti-abortion Republicans because of the gerrymandering. and because of the cutbacks in the Voting Rights Act that have allowed Texas to implement some really restrictive voting policies. And so the court has basically said, we're not going to do anything about gerrymandering. It has said, we're not going to allow the Voting Rights Act to stop any of these things. So states like Texas take advantage of that, district and restrict in a way that solidifies their anti-abortion majority in a way that's not representative of the state. Advocates that I know in Texas say this is not representative of the state. People in Texas don't want this law, but we got it because of gerrymandering. Here in Pennsylvania, we have an overwhelmingly anti-abortion legislature, even though we have a state that when it votes statewide, elects pro-choice officials. Look at Governor Wolf, look at our Lieutenant Governor, Josh Shapiro. Look at our Attorney General, our Lieutenant Governor, John Fetterman. They are all very outwardly pro-choice, and they win statewide elections. But we have such a gerrymandered local state districts that we have a very anti-abortion legislature in Pennsylvania. So all of these voting things have a direct impact on abortion rights.
Okay, and I think we have time for one more question. And this is kind of going to be a combination between Professor Frankel's question and one in the chat. Megan in the chat asks, how does the argument that people have autonomy over their bodies with regards to vaccine mandates jive with anti-abortion advocates? And Professor Frankel asks, would an SB 8 style restriction on other medical choices like vaccination be federally preempted by the FDA's vaccine authorizations?
So the FDA vaccine preemption is tricky. FDA preemption is a really tricky topic. And there are certain things that can be preempted by the FDA and certain things that not. And then there's a lot of gray area. And so I don't know exactly the answer to Professor Frankel's question. I think that this gets to my last point, though. I think our side should be trying everything and not worrying about the ultimate outcome in the case. Because I think too often we lawyer ourselves ahead of time and say we're not going to try it because we're not sure of the outcome, and we need to try things like this. The right to bodily integrity, the court has long protected the right or allowed states to require vaccinations because they say, yes, you have a right to bodily integrity, but the risk of the threat to public health is so great from unvaccinated people in terms of spreading communicable diseases that it outweighs this right to bodily integrity. And so I think that risk of spreading to other people and harming them just isn't true with abortion, right? Just because someone gets an abortion, it doesn't mean that hundreds, thousands of people in their community are going to get sick and risk dying. It's irrelevant to those people. So there's just a big difference. Yes, all of it has to do with bodily integrity, but some bodily integrity rights give way when massive public health risks are at stake.
Thank you so much, Professor Cohen. I've really enjoyed this discussion. I feel like I've just given you a law school exam. I'm going to turn it over to Kelsey to close us out.
Thanks, Emily. Thank you so much, Professor Cohen, for leading our concluding discussion, sharing your insight and lessons for looking forward, and of course, for leaving us with a little bit of hope and inspiration after explaining the rather depressing outlook for the future of Roe. I'd like to thank everyone for attending today's symposium on the current state of reproductive rights and how those rights have been impacted by the COVID-19 pandemic. For me, the purpose of attending symposia and conferences like these is really to learn and be a part of and witness to thoughtful and provocative dialogue. I certainly believe this aim has been accomplished today, and I think I can speak on behalf of the entire Drexel Law Review when I say that our panelists have far exceeded our expectations in bringing these issues to light and charting a path forward. I hope each of us will take what we've learned today back into our lives, whether academic, personal, or professional, to meaningfully contribute to conversations and, most importantly, action surrounding access to healthcare, defending reproductive rights, and promoting reproductive justice, and especially to continue this dialogue with those who are not in attendance today. Thank you once again to each of our panelists and speakers and to our moderators. I would also like to give a special thank you to Professors Elizabeth Kakura and David Cohen for helping to bring life to this symposium, and to our faculty advisor, Dean Deborah Gordon, for your help leading up to this day. And of course, thank you finally to our executive symposium editor, Emily Larrabee, for putting on this fantastic program, and for all of your blood, sweat, and tears that I'm sure went into the day. So that concludes today's symposium. I hope you all keep the Drexel Law Review on your radar, and please look out for our symposium issue, which will be published in the spring, and it will include articles written by several of the speakers you've heard from today covering what was discussed and more. Thank you again. Have a great evening and stay safe.